The topic that Frank Gaffney had asked me to talk with you about is one about which I published an op-ed in the Wall Street Journal a few weeks ago. I apologize in advance. It's kind of a technical subject, but I think it's of quite large importance for American national security policy, and also for understanding what the Obama administration is hoping to accomplish strategically. The administration announced a few weeks ago that it was going to start affording to wartime detainees protections under Article 75 of a treaty known as Protocol 1 to the Geneva Conventions. And in making this announcement, the administration said that it is adhering to Article 75 of Protocol 1 out of a sense of legal obligation, which is very carefully formulated language that tracks the key language in the concept of how laws become customary international law. Now, let me try to unravel some of this for you and explain why it's significant. Protocol 1 to the Geneva Conventions is a treaty that was negotiated in the mid-70s. It's the major rewriting of the famous 1949 Geneva Conventions on the laws of war. And at the time that this rewriting was done in a big international conference in the mid-70s, there were two treaties that came out of the conference, Protocol 1 and Protocol 2. Protocol 1 dealt with international armed conflicts, Protocol 2 with non-international armed conflicts, basically civil wars. Now, the Protocol 1 was extremely controversial. And one of the main topics that it dealt with was giving protections to so-called national liberation groups. And these were groups, many of which were using terrorist tactics. And so under the laws of war, fighters for these groups did not receive combatant status, or if they were captured, prisoner of war status under the Geneva Conventions. And one of the main things that Protocol 1 did was it said, it basically created a favored category for these national liberation groups and said, even if they don't comply with the normal rules for getting combatant status and prisoner of war status, they should still get that status. So even if they don't wear uniforms, even if they don't carry their arms openly, even if they're not part of a regular chain of command, even if they do not comply with the laws of war. Anyway, that was one of the main provisions in Protocol 1 that led Ronald Reagan in 1987 to formally inform the Senate that the United States would not ratify Protocol 1. I mean, there were a number of reasons. Protocol 1 has many provisions in it, some of which are perfectly okay, but some of which were innovative and very not okay. And President Reagan came to the conclusion that Protocol 2, the one dealing with civil wars, would be acceptable to the United States with certain reservations, but Protocol 1, he said, we have decided not to ratify. Okay. Now, no president since President Reagan has disagreed with this. When President Reagan made that decision, it was on the basis of the unanimous recommendation of all of his top civilian and military officials. And so no president since has said President Reagan was wrong. No president since has said he supported Protocol 1. None has submitted it to the Senate for ratification. The Senate has never acted on it. The United States is not a party to Protocol 1. But now you have the Obama administration announcing that Article 75 of Protocol 1 is somehow a legal obligation for the United States. And you wonder, doesn't that raise questions about who makes law for the United States? And we basically have two ways of something becoming law for the United States. Or you could say three, but let's talk about all three. The two standard ways that something becomes law for the United States is Congress enacts a statute. The second way is the president concludes a treaty, submits it to the Senate for approval, and if the Senate approves it, the president ratifies it. Those two ways are discussed in the Constitution, and it says that statutes and treaties in force are the supreme law of the United States. Okay, those are the two standard ways that something becomes law. There is a third way, which is the way something gets recognized as law, and that's the area of concern here. The third way, which is a way that's been recognized in American courts going back to George Washington, is there is a concept known as customary international law, where certain things that countries have done almost universally for very long periods of time that are done under a sense of legal obligation are eventually recognized as customary international law. Now, what is in that category? Well, the law against killing diplomats. I mean, something that goes back thousands of years. And as I said, it's not that it's always respected, but it's widely respected as a legal obligation. Now, what's happening here is President Obama is implying, now he didn't say it outright. I mean, he did it in a rather clever way, because if he had said it outright, it would have created more controversy. But he used the formulation of customary international law by saying, you know, we are adhering to Article 75 of Protocol 1 out of a sense of legal obligation. That's the international legal formula regarding customary international law. Now, Protocol 1 has been around since the mid-70s. It now has a very long list of parties, something like 170 or so countries. I don't know exactly, but it's a large number. But it's been around for a few decades. Now, if you think about that, if a treaty gets endorsed by a long list of countries, and the idea that after just a few decades, as opposed to a few thousand years, after just a few decades, it can be recognized by the President of the United States as law binding the United States. What that means is the United States loses its ability to decide which treaties it wants to be party to. And it is true that the concept of customary international law has been recognized by the Supreme Court for a very long time. I'm going back to the earliest days of our republic. But it hasn't been used very much, and there's a question of what are the boundaries here? What are the rules for what are the proper considerations? Because if a president of the United States can recognize something as customary international law just because it's basically been in fashion in international circles for 20 or 30 years, and he could declare it to be law without Congress, and not only declare it to be law, but declare it to be law in a case where the treaty involved is a treaty that the United States government has specifically addressed, and President Reagan said, we have formally decided not to ratify it. It raises very serious questions about who gets to make law and what kinds of trapdoors are there through which something can come in circumventing the Constitution and be declared to be legally binding on Americans. I think that this is a it's a matter of great consequence in particular because it fits within a broader movement known as the transnational law movement that I will say a few words on, and then I think I'll stop and be happy to take a question or two. The transnational law movement is a movement of mainly a combination of mostly foreign officials, academics, and it has some American support, which before the Obama administration was largely in academic circles. President Obama has brought one of the most brilliant and important proponents of transnational law, Harold Koh, the former dean of Yale Law School, into the government as the legal advisor of the State Department. And Dean Koh's writings have emphasized that there is a set of ideas, of progressive ideas, that legislatures in democratic countries have been resistant to adopting. And he has highlighted the fact that a lot of these ideas, which he considers to be, good ideas, are simply not popular in democratic countries and don't get adopted by legislatures. And he has said that if those ideas can be recognized as rights, rather than simply matters of policy that can be the subject of democratic debate, but they are recognized as rights, and you can persuade judges that those are rights that are rooted in the practice of the international community or the best writings of the legal scholars, then those things can be, in effect, incorporated into the law of countries that are resistant to the ideas when their legislatures deal with them. And he's written this explicitly, and he's specifically talked about it from the point of view of how do you overcome the resistance of countries that have legislators that won't pass these ideas. And he said in the transnational law movement is a way of, basically what it does is it turns progressive legal scholars into a legislature of sorts. So that if you could cite enough of them and show that and especially they've been particularly influential in Europe, much less so in the United States so far. American law is if you can get American courts to be citing the practices of the European Commission, the practices of European courts, the legal scholarship of various progressive, well-credentialed lawyers and universities around the world. If that becomes your source of authority, then a lot of these ideas can become law without going through the nasty, dirty, time-consuming, and often unsuccessful business of trying to get them legislated. So you see, given that there actually is a substantial political movement, I would label it political because it's basically, it's not that there are conservatives who have this view and liberals who have this view and they battle it out. This is basically just a progressive field of activity, this transnational law movement. And now, recognizing that there is that movement, one sees that customary international law can become a very effective vehicle to ride for the advocates of this particular approach. It is, I would argue that it's an approach that is disrespectful of democracy in principle. It's an approach that is specifically disrespectful of our constitutional processes. It is no coincidence that many of the leading proponents of transnational law write disapprovingly of the idea of national sovereignty. They believe that national sovereignty is a problem to be overcome, not a principle to be preserved and protected. And so what I'm trying to explain is that there is a broader context for worrying about what looks like a highly technical announcement by the administration regarding Article 75 of Protocol 1. I'll end on one particular observation. It is interesting that when President Obama made his announcement on this Article 75. Now, by the way, what Article 75 does is it provides certain protections to wartime detainees in international armed conflicts. Substantively, I don't think it's enormously controversial or a very big problem that those detainees would get those protections. So I want to make it clear, I'm not arguing that the substance was so terrible. I mean, one could debate elements of it, but basically, I don't think that the substance was so terrible. What was terrible was the suggestion that we are legally bound to follow the article, an article of a treaty that the Senate has never approved. That's what's terrible. If the president, exercising his constitutional authority, had wanted to announce and use an executive order or a regulation, or a DOD directive or some other device that's within our constitutional system, had he wanted to take the substance of Article 75 and say that is American policy, I don't think that would be a problem. The problem is this idea that the president can take something that's 20 or 30 years old and declare it to be customary international law or imply that it's customary international law and thereby circumvent the Congress. I think this is something that the Congress can address, and I think that we should all start thinking about what would be sensible legislation for Congress to take to try to apply some rules that presidents can use before they can declare recognition of some concept as customary international law. Because as it is right now, it's, the license is so broad. There hasn't been a lot of abuse of this in the past. I think this was arguably an abuse in this case. And I think that Congress could address this and say there are certain procedures or certain rules that should govern when a president, how a president would adopt a concept as customary international law, and I think that could help protect our constitutional legislative practices. Anyway, I think that's basically what I wanted to talk about, and I'm happy to take a question or two.
Let's definitely open this up to questions. Let's start on the back, on the left there, on my left. And please state who you are and your organization.
Yes, Wayne Bowles of the Bowles Company. You stated that Congress should take a look at crafting rules for this. Would it be done by statute, by statutory law, or would it be necessary for a constitutional amendment to be passed?
It's an interesting question. I would think that you could accomplish it by statute. What might happen is if you pass a statute and somebody challenges it, if it goes through the courts and they decide that the statute interferes with the president's constitutional authority, then it's the kind of thing that somebody might want to address in a constitutional amendment. I would not start on the constitutional amendment point. I would think that there are certain things that could be usefully done through a statute.
And Maury, here on the right. Oh, sorry. Go. Just speak up. It'll be okay.
I'm now speaking as a Harvard Law School class of '61. We brought the subject up with my classmate Tony Kennedy this past weekend because he had cited some foreign law as applying it, and we gave him a very hard time on that. So the problem is not only with regard to overstepping Congress, but within the judiciary, applying foreign law to setting cases here.
Yes, no, that's absolutely right. I mean, when I said that the transnational law movement has been more effective in Europe so far than they've been in the United States. I did have in mind the fact that their advocates of the transnational law approach have succeeded in arguing and getting some judges, including Supreme Court justices, to cite as, in some cases, they cite them for the weight of the opinion, and for some cases they would argue its authority. They cite what other judiciaries in other countries say or do. I mean, the way it comes up is in things like when people are talking about the death penalty, and people will raise questions about, you know, is it cruel and unusual under the American Constitution to apply the death penalty? And somebody will make the argument that civilized countries, citing other countries' practices, right? Civilized countries do this, and that somehow should be viewed as a weighty argument that what we are doing in the United States is not consistent with the general opinion of civilized humanity. And so that's how these kinds of things come up. And there's a question of, you know, how much weight should be given to the practices of other countries, and because, again, when you're talking about something where you're defining it as a right, once you define it as a right, judges can start applying it as law, even if the legislature has not spoken on the subject.
Dan, go ahead.
Dan Pollock with the Zionist Organization of America. Well, two parts. Could you comment briefly on, I think the exact strategy you've been talking about has been used to great effect in Europe in getting around local opposition to things that they're calling rights in the European Union. But it seems to me that even if the president should proceed and implement these types of ideas through executive order, if a number of presidents do that in a row, we essentially, in a slower manner, end up with the exact same result, and that it becomes accepted American policy for several presidents to do it, and then there really isn't any disagreement. Do we need to draw the line more sharply on some of these things and actually push for the reason that President Reagan didn't want to treat these illegal combatants as illegal combatants is it doesn't give the right incentives for people that were fighting.
But I want to make it
Go
ahead. I hope I didn't mislead anybody by explaining at the beginning the substance of President Reagan's objection to Protocol 1. I'm not saying that what President Obama did in this case was give protections to terrorists. I mean, I'm not making that substantive argument. I'm saying that the problem was that he didn't do this by executive order. The president has authority to do things by executive order, and that's fine. And a president can issue an executive order, and another president can revoke it and issue a different executive order. And that's why we have elections, and that's democratic, and that's constitutional, and there's no problem with it. The problem is if the president of the United States says, I recognize as customary international law a certain proposition, and that is binding on the United States without our Congress ever having passed it.
Understood, but isn't it also true that if President Bush had a policy, President Obama has a policy, and his successor has the same policy, over time you end up with eroding the capability of the future president to make an independent policy if this customary law?
No. Customary international law is a different. There are. You could argue that there are certain things that become customary politically in the United States, and then the past practices of presidents make it harder for future presidents to do something different. I think that's a different problem.
Carol, can we get a mic over here?
Thanks. Doug, you mentioned this is a form of political warfare. It's not legally binding. And so in Israel, there's all of this hysteria over what will happen in the UN General Assembly in September with the Palestinian Statehood Declaration. And I think that that's basically us kicking ourselves because we're empowering something that really has no legal weight. And it seems to me that since this is a form of political warfare, in this case against the U.S. Constitution, that it has to be fought in the political arena and not by trying to legislate something, because this is not, because that's giving it more legal weight than it has. And transnational, international lawyers can say anything that they want to. But so long as, at least from a binding legal perspective, the United States' laws are based on the U.S. Constitution, it's just a matter of political will. He'll be replaced by somebody else, and there'll be a different policy, and this remains a reflection of what he actually wanted to do, as opposed to a transformation of the legal order of the United States.
I don't agree that it is merely a matter of political debate.
Okay, so
because
why?
Because there's if something is recognized as law so that judges across the country apply it as law, that's significant. And the basic question is, who gets to make law for the American people?
Do we think that he's doing this, I mean, what he could otherwise do as executive order or by statute or whatever, but he's citing this legal doctrine because he wants to advance the legal doctrine and he wants to be able to do this in the future and push this sort of concept of transnationalism?
Yes. I mean, that's the thing. If he had not appointed important voices, I mean, really serious, thoughtful, important people like Dean Coe, I mean, who was really a formidable person, a great scholar, and a passionate advocate of this, what I would call a political movement. If he had not appointed him as legal advisor of the State Department and made other appointments of other vocal advocates of transnational law, then you could view something like this as maybe an anomaly. But I don't think it's an anomaly. I think these people that he's appointed show that there's a view, a carefully considered view, that the United States would be better off acting more in the way the Europeans act and adopting these transnational legal theories and approaches. And this is a step. It establishes a precedent, it establishes a way of doing business that is an endorsement of that whole school of thought. And it's early. I don't want to be alarmist about it. I don't think that the Constitution is halfway down the tubes. I think this is a redeemable situation. I think that Congress will have a chance to have its voice on this. I think it can be corrected. I think that if even though it's a highly technical issue, I think that members of Congress whose constitutional authority is directly threatened by this can understand it. And I think that there's a reasonably good chance that they will take some kind of action and deal with it. So, you know, as I said, it's not a hair on fire problem, but I think it's a serious matter and it should be addressed.
Okay, thank you so much. This is terrific.